Okay, everybody, we're going to go ahead and get started on our slide deck, and we've got a couple of different people here today to help present for us. So I think this is going to be a very beneficial residency liaison meeting for the month of April. So thank you for joining us today. And without further ado, we'll go ahead and start moving through our slides. For those of you on the telephone, I'm on slide number 3. As you know, just a reminder, we do receive questions and sometimes agenda items through the invitation submission form that I send out every time we have an invitation for a residency liaison meeting. And we really encourage people to please submit questions or agenda items through that form because it helps us keep this meeting very relevant to you. Because we want to make sure that this meeting has value. So the question that we received was kind of a question to clarify the conversation that we had in our last meeting, especially as it applies to DACA students. And I think there may have, in that conversation, been a little bit of confusion. And so I just want to clarify that the protocols and the policies and the processes for DACA students has not changed. Everything has remained the same. So there's no change as far as our residency is concerned for DACA students. And I'm going to pause there for a second just to see if there's any verbal questions. Anybody wants to unmute their microphone, or if anybody wants to put a question in the chat. But just to repeat one more time, no policies, no procedures, no processes have changed as far as DACA students or students that do not have any documentation. Those processes and procedures remain the same. So I'm going to pause here a second to see if there's anything in the chat box, or if you have a question, please feel free to unmute. Okay, I'm not seeing any questions in the chat or hearing anything, so we'll go ahead and continue to move forward. I didn't check, but I hope Tracy is on the line for us from RDS this morning. Tracy, were you able to join us? If Tracy's not here, Jean, would you be able to cover the statistics that Tracy was planning to cover?
Sure, I can do that. Or if you want to wait and see if she joins, I can go ahead with mine. Either way.
We could go whichever direction you prefer.
Okay.
So I'll go ahead and move down to your slides then, Jean.
Okay, that's fine.
All right. So those of you following along on the phone, we've jumped all the way to slide number 8. And Jean Ritter is going to give us some SEAA updates. Jean,
so good morning. I'll just say briefly about the quarterly statistics, and if Tracy joins us a little later, she can amplify on that. But basically, as we're all aware, the numbers are down and continue to be down compared to what they've been in the last year or two. Keep in mind that part of that is we started that continuous enrollment update that's automatic. So a lot of students who in the past would have had to come back, let's say, because they're looking to transfer to a 4-year, would not necessarily now. We've been automatically extending tens of thousands. So that also figures into the to the mix there. While we're on that about statistics, she and I had a conversation about, she reported 4 SEA appeals the last quarter. I'm going to work with her to modify that. We actually only heard 2 appeals in the last quarter. 2 of them were canceled. One of them didn't complete it in the timeline. It timed out, and the other one withdrew it because they realized they'd made an error. So we only heard 2. They were both sustained. Both of them are the most frequent scenario we have. These are students who came here from out of state. They're at a 4-year institution. They've been here 12 months, and they're trying to qualify as in-state residents when they're really not independent. They have no income, and their parents are continuing to support them, but by their mind, they've been here 12 months. So we just had the 2 SEA appeals we heard that were sustained. On here about the guidebook, I did have an extensive conversation and follow-up. As you know, the guidebook and the official campus responsibility manual have been under legal review at SCAN, And I did get the feedback and some edits. However, since then, there's been some changes that I'm going to talk about now. Actually, last week there was another legislative change. I have to build in some edits. So right now, I'm going to go back with one last draft to the attorneys. And the goal is in the next month or two, we'll have this over the summer. And then as a follow-up to the last training we had, which I appreciate everyone's involvement in, and we got some really good questions, we're going to have a follow-up training probably September, based on Monty's survey of folks after we're through peak registration. We did this about 2 years ago, where it focuses in on what are the campus responsibilities, when does a campus have to track, if it's a campus-based exception, the paperwork involved. And at that time, we'll go through those newly released manuals. Okay, so it's coming soon. We've been working on this for a while. I'm aware of that. Legislative proposals update. One of them was signed on Friday by the governor, House Bill 53. And basically, this is one we were aware of. It is not going to make a change for RDS or really the campus. It's more to be aware of it. These are for students who are in high school and the parent is active duty military. Okay. So they got that exception, the out-in. They're non-resident, but they got the blanket exception. However, the service member gets transferred prior to the start of classes the following fall. This amendment and statute allows them to keep that out-in determination. Currently, or what we've been doing in the past, is it would be valid only if they'd already started classes and enrolled at that institution. So just be aware that some campuses proactively run lists and notice if someone changes a permanent address. But if they previously were admitted with that out-in determination and the parent subsequently transferred, they can keep that as long as they're enrolled at the same college and same program, even if they hadn't started. However, the provision is they must start in the following fall. That's a lot to digest. Basically, it's just FYI. There's nothing you have to do special at the campus level. Just be aware of it, that they might not lose the determination. And JW, this is very recent. It was signed by the governor on Friday. So what I'm going to do is write this up and send it to you to send out to everyone on the list if we could. Okay, just a couple of others. We are aware of it. There's, a pilot program proposed for one particular. DACA came up. I've already had calls saying, oh, isn't there going to be a legislative change in DACA? There was a bill filed fairly recently. It's been sitting in committee. I will tell you, please be careful. I usually don't announce this, but I've already gotten several questions about it. Yes, we're aware of it, but there have been similar bills introduced for several years now, and they've not moved forward. We're aware of it. We're tracking it. If there were any changes, we would let you know. And finally, there's one more, and JW, I'm going to let you and your general counsel address the one, the Senate bill pertaining to the proposed changes in expanding the high school grants. So we're aware of those and tracking, but the only one that's been signed is this one. As I say, I'll follow that up. It's more FYI that the student would not lose the determination as long as they enroll right after their senior year. Okay. We talked a couple times about the changes to the Veterans Choice Act. Just again, because I'm still getting questions about it, this is for whoever does the certifications in your campus, usually financial aid folks, that currently, if let's say the family just moves to North Carolina, they don't meet the 12 months residency requirement, they can get a waiver under federal law in the Veterans Choice Act if they meet certain conditions. Currently, part of the condition is they have to do this within 3 years of discharge of the service member, discharge from the military. That 3-year cap is being lifted. So it will now be effective August. Anyone who gets certified and awarded by the VA, the campus can apply that benefit to adjust. They'll still be a non-resident, but they're eligible for the in-state tuition. Okay, so your financial aid folks should be aware of it. Currently, it doesn't change the rest of the provisions under federal law that they have to meet. And it can't just be that someone was a veteran or discharged at some point. They must have and use the benefit to qualify for the tuition change.
Gene,
And yes.
This is Monty. Good morning.
Good morning.
This will be in the guidebook or the campus responsibilities, this new change?
Yes.
Okay.
That's one of the edits that I've sent back. Meanwhile, RDS is aware of it, and we're making changes to the interview to pass that information on to campus. That's, if not done, will be done imminently. So the student will still get flagged. It's that informational VEDX flag, the veterans exception flag, that gets passed on to the campuses. And basically it has to be verified with the VA that in fact they are eligible and do have a benefit. But yes, that's one of the changes, a couple minor immigration changes and whatnot. I've sent in some more edits.
Okay.
Okay.
Thanks, sir.
Sure. And then finally, we've talked about this, that based on legal guidance some time ago, we've kind of kicked out the implementation of it. But next month, and we will send out when the change happens on an online interview, the legal interpretation is someone, when they turn 18, who wants to be considered independent, unless they have another factor in there that we would look at, such as marriage or something, but your typical student, when they're 18, would have to begin to establish domicile, and they wouldn't meet the 12 months until they're 19 if they're trying to be independent. So we're going to figure that into the interview. Honestly, this is not many, because most students at 18 are not able to show financial independence, for example. They haven't been paying taxes generally, in terms of filing their own tax return. I don't think this is going to be a huge impact. We have looked at the numbers, and that's part of the spirit of the proposed change for the high school exception. And I'll let you all talk about that. But keep in mind that the students do not have to be living with the parent. We get a lot of this from high school counselors, because their definition in the public schools under McKinney-Vento is the student has to be living under the same roof with the parent. Otherwise, they consider them homeless and independent. They do not have to be here. As long as we can verify the parent is in state, they don't have to be living with the parent. And sometimes they have a hard time getting information. That's what an appeal's for. So we'll continue to work with them. There's a 5-year rule if they've been here long-term with a relative that will qualify. I'm not sure this will be a huge number. This is simply for the ones that turn 18 and want to try to qualify for independence on their own merit. So that's what I have. I want to see if there's any other questions about any of those issues.
As always, thank you, Gene. We appreciate that. We'll give it a second to see any questions that pop up here in the chat box, or if anybody has any questions, feel free to unmute. Okay, well, thank you, Gene. We really appreciate that. I didn't see Tracy come back on the line, so we will check in with her again at the end to see if she's becomes available and is able to join us. In the meantime, we'll go ahead and start moving through to our next slide, and that's updates here from the system office. One thing I do want to mention before I talk about the slide is that Monty and I have been in a little bit of conversation, and of course he will send out information concerning the training on the updated guidebook as soon as we can get those all of that coordinated, and we get ready to publish that campus responsibility manual. Monty is the guru of all things training, and I appreciate his efforts and everything that he's doing with that.
Ha!
Go ahead, Monty.
I just laughed.
Oh, okay. So we'll go ahead now and move to slide number 10 if you're following along and you're on the telephone. And this is the amendment to GS 115D that Gene mentioned. It's Senate Bill 421, and we appreciate the senators that were willing to help support us and to hear our need when it came to this amendment. Basically what this amendment does, and you can see the hot link here, the amendment allows that if this is adopted, okay, let me let me say that to make sure we're clear, if this is adopted, is that if a high school, recent high school graduate who is under 19 years of age and meets a few other criteria and enrolls the following fall, so immediately that fall after they graduated high school, then they would get that one academic year as in-state, even if RDS has classified them as out of state. So that would give them, so they would come across as an OI, basically. So what this would give the student would be 1 year to get their get all their paperwork together, get everything in place so that they could establish and prove the residency by the time they turn 19. Because we know that there are about 1,400 students across the state that could fall into this gap. And so we see this as a safety net to help take care of those students. Please note that one of the criteria for this bill is that you have to be a U.S. citizen. And so it does not deal with any of the immigration statuses. So we're hopeful that this bill will continue to move forward and will come to fruition, hopefully, as quickly as possible. But with the General Assembly and dealing with the budget this year as well, we don't know for sure how long it will take for this bill to be heard, and hopefully the governor to sign it eventually. So I'll pause here to see if we have any questions about this proposal for our recent high school graduates. Okay, not hearing any or seeing anything in the chat box, so we'll continue to move forward. I am glad to kind of introduce to you, since I just met her just a few minutes myself, just met her a few minutes ago, and that is Ms. Tawanda Artis. And I don't even know for sure, Tawanda, if I pronounced your last name correctly. So if you could take a minute to introduce yourself. Tawanda is our new general counsel here at the system office, and she's been talking to John Harris, who was just promoted to chief of staff. And we've had this question on the table here for a few months, talking about lawfully present and lawfully admitted, especially how it applies to some of the exemptions for the community colleges. And so Tawanda, on her whole second day at the system office, has generously agreed to talk with us a little bit today. So I'll be quiet now, Tawanda. I apologize, I'm rambling a little bit. But if you could introduce yourself and then share with us what your guidance is concerning the lawfully admitted and lawfully present.
Well, good morning, everyone. I'm happy to join you today. It's actually my second week, JW, so I guess that makes it my 7th official day.
Okay.
I don't know that that makes it any better, but I'm happy to be with you all. I'm a career state government attorney. Law is a second career for me, and I've worked in state government for about 17 years across 4 different state agencies. I'm practicing a variety of legal issues. So I'm excited to be here and excited to contribute to the community college system. So let's get started. The big issue that I think keeps coming up with the statutes and the federal law around lawfully admitted and lawfully present is a little bit confusing. So the first thing you need to know is that the statutes will control. And so lawfully admitted is referenced in GS 115D 39B. And it says any person lawfully admitted to the United States that 1, satisfies the qualifications for assignment to a public school, and 2, graduated from the public school to which the student was assigned, shall be eligible for the state resident community college tuition rate. So a few things, let's unpack that. First criteria is they have to be lawfully admitted. If they are lawfully admitted to the U.S., which speaks to how they came into the country, and they satisfy the requirements for assignment to a public school, and they graduate from said public school, then they qualify for the in-state tuition rate. And that's clear, cut and dry. It makes no distinction between documented and undocumented. I think, and let me go back, when we talk about lawfully admitted, that is described in federal law, and it says admission or admitted related to an alien, lawful entry of an alien into the United States after inspection and authorization by an immigration officer. So if the student is able to show that they were approved for admission into the United States by some immigration officer, it doesn't matter what type of document they have, as long as they were lawfully admitted under our state statutes, they qualify for in-state tuition. I think maybe what makes this confusing is some other places in law, we talk about lawfully present, which speaks more to current status as opposed to status once admitted to the country. One such place that kind of muddies the water for us is in our State Board Code. In State Board Code 400.2, that talks about admission to colleges, it talks about undocumented immigrants being anyone who is not lawfully present in the United States. And also makes the requirement that an undocumented immigrant admitted shall not be considered a North Carolina resident for tuition purposes. So you can see there's a little bit of gap and difference in the law there. Because State Board Code are considered rules, they do not trump federal law or the state statutes. So the state statute is what controls 115D 39B. And John and I have talked about some possible solutions. While rules cannot control, so the State Board Code will never overrule a state law, they can be what we call gap fillers. And I think there is a gap between the law in terms of lawfully admitted and lawfully present. And so there may be room to do some rulemaking in the State Board Code to fill that gap. And we're happy to continue to talk to you all and the leaders here about that and whether or not that's appropriate going forward.
All right, Tawanda, thank you. I appreciate that general interpretation. I do have one specific, I'm going to put you on the hot seat for a second. I do have one specific question that I know is on the minds of a lot of our residency liaisons and admissions officers. The scenario that they find themselves in often is that a person is lawfully admitted. They go to and graduate from their assigned public high school, but then their visa expires for whatever reason. So they currently do not have a status of being, quote, lawfully present and don't have a current visa. And so historically, we have interpreted that to mean that they don't qualify for that North Carolina high school graduate exemption that's currently on in legislation that you referenced. So are we making a change in that interpretation? Are those students still not eligible for the North Carolina high school, or are we saying that because they were lawfully admitted, regardless of their current status, they are now eligible for that high school graduate exemption?
The law says clearly if they are lawfully admitted, they are eligible for in-state tuition. So our advice is that you must follow the law. So if that has not been your interpretation previously, I think you need to revisit that. And it does have to be lawfully admitted. If you want some gap filler language in the code that talks about lawfully present, that's something we can talk about going forward. But I think the law is clear and we have to follow the law.
Okay. Thank you, Tawanda. I appreciate that. That is a change in practice, and that's a little change in interpretation from previous council. And so we appreciate your interpretation today. So I'm going to repeat it one more time, just because this is a major change for everybody, and I want to make sure they hear it. And that is, we're doing these, what I call, as a non-attorney, the simple interpretation of the law, and that is lawfully admitted means you were admitted lawfully as defined by the federal government. It does not take into account your current status. And so if you graduated from your assigned North Carolina public high school, and you were lawfully admitted, then you qualify for that community college exemption.
Yes, and I want to clarify, JW, that is not just an interpretation of lawfully admitted. That is what the federal code says, the US code says. Lawfully admitted means an alien who gained entry into the United States after inspection and authorization by an immigration officer. It has no stipulation about what type of visa, what type of documents, or that those documents must still be current to be considered lawfully admitted. And I know that you and I and Jean and John have shared some emails about this, and a student whose visa expired, but had also applied for asylum and had a pending asylum application. And we talked about that situation a lot too, and it seems that that student is still lawfully present, even if he does not have a current visa, because he has the pending asylum application. So until asylum is denied, he would still be lawfully present.
Okay, thank you. So because they have a pending application, okay, thank you. That's very helpful. So one thing that I want to ask Monty to do is, Monty, we probably need to take a close look
Yes.
at our guidebook, right, to make sure we're consistent with what we've heard today. And especially the campus responsibility manual, not the guidebook, but the campus responsibility manual, because that's where it'll cover this exemption.
Yeah, so what I'm probably going to do is probably get with Jean, you, the council. Good morning, Ms. Artist, and probably a couple of my campus administrators, and see if we can go through that guidebook and hash through that.
Okay.
You've thrown us a curveball early in the morning.
Well, I'm happy to help.
That's good.
I can with the guidebook and the responsibility manual. It's not just my curveball now. We're gonna give John some credit here too.
Well, thank you, and I don't know if you're reading the chat, but you're seeing some very positive comments in the chat box there. This is instead of a change in interpretation, how about if we say a change in process and procedure and application of the law to be a little more accurate. It looks like we do have one question here. Would students who enter the country on a tourist visa, which would be the B1 or B2, be considered lawfully admitted?
I think so. And I think, and that's saying not knowing what the stipulations are on tourist visas. So let me give you that caveat. I don't know how long you can typically get a tourist visa or what the limit is. So if anyone knows that and wants to put it in the chat, feel free. But I think as long as what the federal law says, it was approved, inspected, and authorized by an immigration officer, it meets the definition.
Right, thank you. You would still, just as a side clarification comment, is that you would still have to meet the other criteria for that exemption, and that's graduating from the high school.
Yes, and providing proof of that, yes.
Yes, ma'am. All right, so I'm going to pause here to see if there's any other questions that you want to put in the chat box, either on this topic, or we'll go ahead and broaden it since we're at the end of our meeting now, to see if there's any other questions that maybe that you have from any of the presenters, and either from Tracy, Jane, Tawanda, or myself, or Monty. Is there any questions?
JW, this is Michelle from Coastal Carolina Community College. How are you?
I'm doing great, Michelle. It's good to hear your voice.
Yes, thank you. I have a situation I'm trying to figure out. We have a student who's trying to attend in the fall. They were here last summer, so they have an RCN expiration date in June. So they cannot register for fall classes, and RDS is telling them that they cannot redo their residency because it doesn't expire until June.
And they attended in the summer term?
Correct, last summer. So they missed a fall and spring, so they do not meet the continuous enrollment definition.
Okay, that's what I was going to ask. Okay. And
So JW, if I could, no,
yes,
that's misinformation or the student misunderstood. The student
Okay.
could just log in at any time and do a reconsideration. They
That's
could
what
just log in right now, and it will automatic. In fact, it gives them the option of saying my determination is going to expire. I think there must have been a misunderstanding. Sometimes a student uses language like, "Can I appeal it?" or "What can I do?" And well, it's too late for an appeal. Yeah, but they can just log in themselves and do that.
Okay.
If they have a problem, yeah, have them call, but I think that's a misunderstanding, Michelle.
And I believe that they spoke to someone on the phone, and my assistant registrar was with them, and was talking to the person as well, and the person explaining it to them on the phone told them they could not do it until June.
No, that's not correct.
Okay.
If you want to contact me with the student information, I'll put a note in the record, or we'll help walk it through, and I'll make sure there's a note in the system or something. We'll help resolve it.
Okay. Thank you.
excellent. Thank you, Jean, and thanks, Michelle, for bringing that up. Any other questions? Okay, any
JW, if I
closing
could,
comments? Yeah, Jean.
I just wanted to comment on this, and I think that's going to be welcome news about the guidance for this, because as you know, we have a lot of, for example, students that have applied for asylum, and that's something that's a multi-year process. So that can help a lot of students. But I just want to clarify, this can't change RDS's criteria and determination, that this is specific to the community college waiver system. So we did, by the way, we have for years had immigration attorneys on staff that we've consulted with in terms of meeting our general criteria. These are things we're passing on because they are your exceptions. I think this is going to be welcome news for many folks. If there's any confusion about it, I mean, we'll certainly help at our end to iron out the confusion about, you know, what a campus needs to look for. But yeah, this I think will be welcome news for many folks in that. You know, there may be an issue when they go to transfer to a 4-year because it's not going to be, UNCs will not afford the same, but hopefully by then they'll have a resolution to it.
Thank
I'm
you,
glad you
Jean, for
said it,
making
Connor.
that clarification. I appreciate that, Jean, because there is a distinction between the community college exemptions and the residency law that RDS has to follow. And it is a great reminder that many of our students who either is in a 2+2 or in a college transfer, that their community college exemptions will not apply for them, or they will not be eligible for the community college exemptions once they begin at the UNC system, or if they're co-enrolled at both institutions. So if a student is at UNC Greensboro and GTCC at the same time, they could theoretically be charged the out-of-state rate at UNCG, but qualify for a community college exemption while they're at GTCC. So just want to make sure everybody is reminded of that.
And also, it will not impact the community college grant either.
That is correct. Thank you, Monty. Great point.
Yeah.
And that is, if you do not qualify as a resident of North Carolina by RDS, and even if you do qualify for a community college exemption, you're still not eligible for the community college grant, because the grant system makes its residency decisions based upon RDS, not upon the exemptions. Great clarification, Monty. Thank you. Thank you, Jean. Any other thoughts or comments?
JW, this is Elizabeth Blevins from Wilkes Community College, and I just want to ensure that I get all of this correctly. So once it's been approved, will you make sure that an email is sent out, or maybe another quick training just to make sure that we're doing this correctly at our level?
Yes, yes. So I think that's a great point. And as any good student services person, we want some documentation, right? So if I could ask Monty to get with Tawanda and see how we can best document what she presented today, kind of to give us an email out. So that way there's some documentation while we're waiting on the campus responsibility manual to be updated. Would that help, Elizabeth?
Yes, that's very beneficial. Thank you.
Oh, thank you.
Thank you.
All right, and then we do have a question in the chat. How long will residency be extended for students who are currently enrolled in any North Carolina college? Emily, I don't know for sure what I mean. I don't know for sure if I understand your question. So are you talking about continuous enrollment? Is that what you think, Jean?
Yes, I'm sorry, I couldn't find the mute button, but yes, for continuous enrollment.
Okay, so Jean, could you kind of give the parameters for us for continuous enrollment, please?
Yes, the way the continuous enrollment works is files are transmitted to the National Student Clearinghouse that everyone reports to. And if there's a match found, it will automatically, and that's transmitted at the end of fall and spring terms, it will automatically extend the determination one more year each time. So if a student's there a year, it gets extended. If they're there another year, it gets extended again each time. There are some exclusions. Any of those that get these exceptions, that out in, the active duty military, any campus-based exceptions, anything like that are not transmitted. Likewise, the immigration categories that have an expiration. So the visa holders, that they currently hold an eligible visa, it's only as good until the visa expires. They have to come back, show ongoing eligibility, or go into a grace period. So it's most of your students, but any kind of a time-limited provision or exception would not go to clearinghouse.
Okay, thank you.
All right, thank you, Emily. One last opportunity, friends. Okay, well, thank you to Wanda, thank you, Jean, thank you, Monty, thank you for your assistance in helping us provide this meeting today, and thank you for the great information. As everybody knows, we will get the slide deck out with the statistics and with the recording link in the next week or so. And also, our homework here in the system office is to get you some documentation in an email form, probably, maybe from Tawanda's office, or it might come from Monty. Don't know for sure. They'll work out those details. But thank you, everybody, for everything you do. Stay safe, stay healthy, and we'll continue to strive to serve you as you serve your students. Have a great day.